Good morning. I'll just wait a few more moments.
Good morning.
Good morning.
Good morning.
I guess I'll say good morning too.
Good morning. All right, I think we are populated into the room here. So good morning. It is May 9th, 2022, and this is our 6th day of hearing in the Phase 1B hearing on the Kern River applications. I'm Hearing Officer Nicole Kinsey with the Administrative Hearings Office of the State Water Resources Control Board. This hearing is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and video are being recorded, and we will post files of this recording along with the Zoom generated transcript to the AHO FTP site. The YouTube recording will also be available on the AHO YouTube webpage. And I don't have the second half of my script in front of me, although we can all probably recite it by memory. Excuse me. Here we go. If at any time you are experiencing technical difficulties trying to communicate with us today, please send an email to the AHO at admin@waterboards.ca.gov. The AHO staff will be monitoring the email inbox and will let me know. If at any time today I am experiencing technical difficulties and am not able to rejoin the Zoom conference in short order, one of the AHO staff will call a brief recess until I'm able to rejoin all of you. Assisting me today are several staff of the Administrative Hearings Office. We have Nicole Mullins, Amy Blunk, Skylar Anderson, and Kyle Wooldridge. Ms. Mullins will be handling the exhibits today as usual, so if you are a witness, please just ask Ms. Mullin to advance your slides if you are providing a presentation. And for the attorneys, please go ahead and ask Ms. Mullins directly to pull up a particular exhibit that you may need. With that, I'd like to carry over the appearances that we have from last week, but I will ask all of you if there's anyone other than our witnesses today who is joining us and maybe participating for the first time and who has not had a chance to introduce themselves. Please go ahead and unmute yourself and say good morning. Do we have anyone new? Well, welcome back to all of you. I think I'll lay out a brief agenda and my understanding of where we are today. I believe we left things off with Buena Vista having presented all of their witnesses and we had completed cross-examination. I think the place to pick up is with Buena Vista's an offer of their exhibits into the evidentiary record. What I was thinking we would do with cross exhibits is that we would just keep all of those until the very end. So when we know, and we can just do all of those all at once. So just for your planning purposes. And then after Buena Vista, we would move on, I believe, if I have this right, to KCWA, your opening statement, and then presentation of your, what I understand are 2 witnesses. I think I didn't say from my script, we will of course take breaks today per usual. As I'd indicated on Friday, I plan to break for lunch at or before 11:30, and we will have a slightly longer lunch break. We'll return at approximately 1 o'clock. So we'll have about an hour and a half for lunch. So you can plan accordingly. And we will have our usual hard stop at 5 o'clock. And to my witnesses, please ask if you need a break. Don't hesitate, and attorneys as well, of course. Are there any comments on the procedure I laid out or other procedural housekeeping matters we should address before we jump into Buena Vista's exhibits? Great. So Mr. Becerra, I'll look to you, but I'll read off what I have as Buena Vista's offer of exhibits based on the index that you submitted to the AHO, which I realize includes some exhibits from the Phase 1A hearing as well. So Mr. Becerra, would you like to offer into evidence what I have as North Kern 3, 33 through 36, 39 through 43, 46 through 48, and 50, that's from the Phase 1A proceeding, as well as Bakersfield 9 from the Phase 1A proceeding. And then Buena Vista exhibits 100 through 109, 200 through 218, 300 through 327, 400 through 416, 500 through 506, 600 through 675, and 700 through 721.
Yes, we would like to offer those exhibits.
Are there any objections to the acceptance of those exhibits into the evidentiary record for Phase 1B, noting that we did have written objections, which I ruled upon, and I believe at least one standing objection from you, Mr. O'Brien, with regard to the scope of those exhibits. But are there any other objections to the acceptance of these exhibits into the record?
If I could just confirm for the record, Ms. Kinsey, that we stand by the objections that were set forth in our motions in limine.
Understood. Thank you, Mr. O'Brien. And with that, the exhibits that I previously listed are accepted into the evidentiary record for Phase 1B of this proceeding.
And Ms. Kinsey, per discussion on Friday, we will prepare corrected versions of 500, 502, and 503 and upload those as soon as possible. We will mark them as 500C, 502C, 503C.
Thank you, Mr. Becerra. Anything else before we move on to opening the opening statement from KCWA? All right, then with that, I look to you, Mr. Jacobs. Do you have an opening statement that you would like to make at this time?
I do, thank you.
Please go ahead.
All right, good morning to you and to everyone here. The question of Phase 1B is whether there are conditions when Kern River water is available to appropriate under the 6 pending applications. And this question is exclusive of water deemed available to appropriate by the Kern Delta forfeiture. That was the issue of Phase 1A. Kern County Water Agency presents 2 witnesses in this matter. The first witness is Kern County Water Agency Water Resources Manager, Holly Melton. Ms. Melton will describe her job responsibilities and testify about 4 relevant topics. First, she will provide background information on Kern County Water Agency and its operations. Second, she will provide a high-level operational description of the law of the river with a focus on the lower river right. Third, she will describe how the Kern River water users and related agencies address high flow conditions, including discussion of the notice order system and operation of the Kern River California Aqueduct intertie, which we will probably refer to simply as the intertie. And finally, she will explain Kern County Water Agency's suggested resolution of Phase 1B. Kern County Water Agency's second witness is Greg Young. Mr. Young is a water resources engineer, and he will testify about 3 topics. First, he will describe and summarize the 2019 Joint Water Availability Analysis and explain that it was prepared according to a methodology recommended by the State Water Resources Control Board. Second, Mr. Young will describe the lower river right and demonstrate the accounting that tracks diversions and use of the lower river right. And finally, he will support Ms. Melton's testimony in suggesting resolution of the issue presented in Phase 1B. Now, in presenting its case in chief, Kern County Water Agency is attempting to present the appropriate level of detail in addressing the central issue of water availability. This is not a water rights adjudication, nor a proceeding to restrict existing rights, at least according to the AHO's orders and statements during this hearing. Instead, we are engaged in essentially a water availability analysis. Water availability analyses compare available supply with the face value of existing rights. The face value of the existing Kern River water rights are the quantities diverted under the law of the river right structure, minus water flowing to the intertie. Kern County Water Agency's testimony focuses on this appropriate level of analysis and suggests the resolution of Phase 1B should be an order that finds waters available for the pending applications only when the intertie protocol have been followed and an intertie operation declared. This approach accords with D 1196, the subsequent fully appropriated stream orders of the State Water Board, and is wholly consistent with Water Right Order 2010-10. And that concludes my opening statement. Our first witness is Ms. Holly Melton.
Thank you, Mr. Jacobs. Excuse me while I change my view here. And then I will look to you when you're ready. If you need a break to have your witness set up, just let me know, Mr. Jacobs. But I believe we're ready to hear from Ms. Melton. And once I see her, I will swear her in.
There she is.
I see her. Good morning, Ms. Melton. You seem to be on mute. I can't hear you. Or maybe it doesn't indicate you're on mute, but I can't hear you nonetheless. We may have some technical difficulties here.
Your phone looks muted, Holly.
And we can take a break if we need a few minutes. We can take a break for the rest of us, and you can test your audio. I see a nod. Let's go ahead. Let's just take. I know it's been brief, but let's take 5 minutes. Please go ahead, Mr. Jacobs and Ms. Melton. You can work on the audio here, and if we can't get it resolved, we'll come to. We have a suggestion from my team that says try unplugging the headphones and plugging them back in. So maybe you can try a few things. All right, but a 5-minute break. I'll come back at 9:18.
Okay, thank you.
Thank you.
Holly, do you want to try your mic out?
Nick?
Yep, I can hear you now.
Okay,
Great.
thank you. Sorry about that.
No worries.
All right, it's 9:18 and I see smiling faces, so we're ready to get
We're good.
a shot. All right. Thank you.
Sorry about that.
Oh, that's okay. Good. Good morning, Ms. Melton. I hear your voice.
Good morning.
Will you please raise your right hand? Ms. Melton, do you swear or affirm under penalty of perjury that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Mr. Jacobs, you may proceed with your witness.
Thank you. Good morning, Ms. Melton. Please state and spell your name for the record.
Holly Melton, HOLLYMELTON.
And is KCWA 23 a true and correct copy of your testimony in this matter?
Yes, it is.
And is there anything that you would like to correct about that testimony?
Yes, I do want to correct an omission. I included many of the important law of the river agreements, but should have also included the 1964 agreement to the Miller-Hagen agreement as part of the operational law of the river. That agreement is North Kern 40 and has been offered as an exhibit in Phase 1B by Buena Vista.
Okay. Please describe your educational and professional background, including your current position with Kern County Water Agency.
Yes, I received a Bachelor of Science degree from California State University, Bakersfield in business administration with a concentration in accounting. I have been employed with the Kern County Water Agency since 1989. I am currently the Water Resources Manager and have held that position since 2013. My job duties include oversight and management of the, I'm sorry, I may say the agency. I'm used to saying that. The agency participation in the State Water Project, local water management programs, including groundwater banking projects, Cross Valley Canal, Improvement District Number 3 that provides specific flood protection to Weldon Valley residents within ID3, which is located east of Isabella Reservoir, and the agency's lower river rights.
And please describe the Kern County Water Agency's operations, what it does.
Sure. The agency is the second largest state water project contractor and holds a contract with the California Department of Water Resources to receive approximately 1 million acre feet annually from the State Water Project. The agency has contracts with 13 local water districts called member units that are located throughout Kern County to deliver State Water Project water. The agency's member units include Bell Ridge Water Storage District, Buena Mesa Water District, Buena Vista Water Storage District, Coelho Water District, Henry Miller Water District, Kern Delta Water District, Los Hills Water District, Rose del Rio Bravo Water Storage District, Semi-Tropic Water Storage District, Tehachapi Cummings County Water District, Tejon Castic Water District, West Kern Water District, and finally Wheeler Ridge Maricopa Water Storage District. The agency also maintains and operates the Cross Valley Canal, a 21-mile canal that delivers water to and from the California Aqueduct, the Frank Kern Canal, and the Kern River on behalf of 13 participating entities in Kern, Fresno, and Tulare County. The agency also manages or is a participant in multiple groundwater banking projects, including the Kern Water Bank, the Pioneer Property, and the Buena Mesa Banking Projects. And most relevant to these proceedings, the agency holds the lower river right, which I'm going to discuss in a minute, which also benefits the agency's member units.
Great. And now I'd like to ask you a little bit about the law of the river. Are you familiar with that term?
Yes, I am familiar with the Kern River system and the basic operational law of the river water rights structure that exists on the Kern River, and in particular as it relates to the lower river rights.
Yeah, and we've heard a lot about the law of the river. I'd like to ask you a few questions about specific aspects of your testimony. Can you please describe how the law of the river allocates the Kern River?
Yes, as described in my testimony, the law of the river is complex, but for purposes of this hearing and without repeating prior testimony, it is probably sufficient to say the law of the river allocates the entire flow of the Kern River based on total calculated flow and is apportioned among the Kern River interests. The basic allocations are found in the Kern River Water Rights and Storage Agreement of 1962. The 1962 agreement divides the Kern River waters into the upstream group, which includes first point and second point water users, and the downstream group, which comprises the parties holding the lower river rights.
What about storage in Lake Isabella? Does the law of the river address those rights?
In addition to settling allocation rules between the upstream and downstream interests, the 1962 agreement allocated the right to store water in Lake Isabella. Under the provisions of the 1962 agreement, the downstream interests have historically exercised the right to rent storage space from North Kern Water Storage District.
Okay, turning now to the lower river right. What is the lower river right?
As described in the 1962 agreement, the lower river right is a high flow water right that is currently held by the Kern County Water Agency. The right allows Kern River direct diversions and diversions to storage during 2 seasons, January through March and April through July. There are different allocations during those periods, which are shown in my testimony and also in the 1962 agreement itself. The Kern County Water Agency purchased lower rights in 2001.
How does the Kern County Water Agency use water diverted or stored under the lower river right?
So we've heard throughout this hearing so far that the Kern River hydrology significantly varies from year to year. In fact, I think we heard that it's a flashy system, which I think is very accurate. So in high flow years, the agency is able to use its storage rights in Lake Isabella in conjunction with our banking and exchange resources to obtain maximum beneficial use of the lower river rights resource. Waters diverted under the lower river rights are available to the agency's member units and provide broad benefits throughout the county. There is a high and consistent demand for surface water supplies within Kern County, including the agency's member units. The agency has contracts with each of its member units that receive water diverted and stored under the lower river rights entitlement. The vast majority of the lower river rights is delivered to those member units, which is shown on page 27 of KCW Exhibit 021, which details the lower river rights deliveries in 2017. Additionally, all the participants in the Kern Water Bank except Dudley Ridge Water District benefit from the agency's allocation of lower river rights to its member units.
And earlier, you described the lower river right as a high flow right, correct?
Yes.
So the Kern County Water Agency is diverting and or storing water in high flow conditions, but there have been times when Kern River flows have been so high that it has been necessary to direct flows into the California aqueduct via a flood control structure we refer to as the intertie, correct?
Yes, that is correct. The agency and the other Kern River interests endeavor to divert, store, and use as much Kern River water as possible. In certain years and at certain times, however, there has been more water flowing into the Kern River than can be delivered or diverted or stored by parties that have the rights to do so.
And under those very high flow conditions, can you please describe what happens?
Yes, the Kern River Water Master and the Kern River interests, in conjunction with other public water districts and water users, in consultation with the Army Corps of Engineers, coordinate how to address the extreme high flow conditions. This coordination has historically involved a 3-part process as the Water Master and cooperating local Kern River interests, state and federal agencies work together to manage the extreme high flow events. First, a call is issued to all the Kern River interests requesting that they divert as much water as possible into their systems. And this first stage is commonly referred to as the pre-notice order. And second, if there are additional anticipated flows, a call is issued to any and all other Kern County water users to divert as much water as possible through their conveyance and storage systems. This second stage is referred to the notice order. And then finally, through consultation with the Army Corps, the Kern County Water Agency, acting on behalf of the Kern River Interest, Buena Vista Water Storage District, and the California Department of Water Resources, the intertie will be open to allow Kern River water to safely leave the Kern River system and enter the California aqueduct for beneficial use. The operation of the intertie is intended to avoid catastrophic flooding in the historic Tulare Lake bed area. And the Kern River Watermaster has a short agreement with any party seeking to divert Kern River water under the notice order process. The operation of the intertie is the subject of several agreements, which are shown in exhibits KCWA 9, 10, 11, and 12.
Great. What else should we know about the intertie?
The Army Corps constructed the intertie in 1977, and since then it has, as we've heard previously, it has operated in 9 high flow events. A copy of that chart summarizing the intertie operations is attached to KCWA 13. And as shown on the chart, there's been various events. Some have lasted a few days, some have lasted much longer, such as 1983, which lasted for more than 200 days. This chart was prepared and submitted by the city of Bakersfield during the 2010 proceedings that resulted in Water Rights Order 2010-10. The last time the intertie operated was in 2006, which was an unusual event and not caused by the typical high flow conditions that have historically resulted in Operation Intertie. I think this has been mentioned as well. In 2006, there was a concern about the safety of the Isabella Dam, which compelled the Army Corps and the Kern River Interest to swiftly draw down Isabella Reservoir in a manner that required operation of intertie.
I'd like to ask you now about how to resolve these competing water right applications. You've already testified that the law of the river allocates all Kern River flows, and the only time those flows are not diverted by the Kern River interests is when water is flowing into the intertie. With that background, how should the state board handle these competing water right applications?
There's only water available to appropriate when there has been a declaration of a notice order, and including through the time period when the intertie operates. As I testified earlier, the operation of the intertie involves coordination between the Kern River interests and the Army Corps of Engineers. There is not, however, a specific Kern River flow rate nor total annual quantity of water that can be identified as triggering notice order or intertie operation conditions. Frankly, every year is different, and the conditions that contribute to a notice order intertie operations are fairly complex and are always in the context of hydrology and conditions from the prior year or years. For instance, coming off of dry years like Isabella may have very little water in storage, and groundwater tables may be significantly lowered throughout Kern County. In contrast, if there were a multi-year cycle of significant precipitation, Lake Isabella might be full and groundwater tables may be above normal elevations. Following those two very different water scenarios, a subsequent year with high flows and high overall precipitation might be easily diverted, stored, and used under the first scenario of prior dry conditions. The same wet year following a series of prior wet years, however, might find Lake Isabella full and insufficient opportunities for groundwater banking. In that scenario, there could be a notice order and intertie operations.
And what about a year that doesn't have particularly high total precipitation and Kern River flows, but has a really huge precipitation event?
That's another scenario that might involve a year that does not have a particularly large total annual quantity of flows, but instead has a single extreme event or storm lasting several weeks and generating flood conditions during that time. That scenario might trigger a notice order and/or intertie operation. A water availability analysis that's based on comparing annual flows to aggregated water rights, as suggested by the sub-issues posed in the January 12, 2022 notice, might show any water available for appropriation during an extreme storm event, even though there's clearly flood water available. I'm sorry, I misstated that, Mr. Jacobs. I said might, and I should have said might not. It might not show any water available for appropriation during an extreme storm event, even though there is clearly flood water available.
Thank you for that clarification. Well, how should the state board determine the conditions under which water is available to appropriate under these competing applications?
Phase 1B should be resolved by allowing applicants to process their applications for water that is available under the notice order and intertie operations. The AHO's order could confirm the notice order process, but it should reflect the historic cooperative practice of the Kern River interest working with the water master and the Army Corps to determine when notice order is active. As I described, it is infeasible to identify water availability based on annual flows or even instantaneous flow rate, since an empty Isabella Reservoir can store hundreds of thousands of acre feet of water. Allowing applications for permits to divert under the notice order and intertie operations offers an equitable resolution of this matter. It encourages full use of the encourages full use of the intertie resource or Kern River resource and respects the historic law of the river.
Thank you, Ms. Melton. I have no further questions.
Thank you.
Thank you, Ms. Melton, and thank you, Mr. Jacobs. I think we can turn to cross-examination. I will, I'm not sure where I should start. Maybe I should start with you, Mr. O'Brien. Do you think it is appropriate to start with Cross from KWBA first? Do you have a preference?
I don't have a preference, Ms. Kenzie. I think that probably makes sense. Well, let me see. I mean, if Mr. Becerra or others are going to do what I'll call a friendly cross, maybe that would make sense to take care of first.
I'm wondering the same thing. Mr. Becerra, do you have a comment?
First, I think that procedure probably makes sense, but second, we don't have cross for Ms. Melton.
Okay, thank you, Mr. Becerra. Does anyone other than Mr. O'Brien have any questions for Ms. Melton?
Ms. Kunze, this is Colin Pierce for City of Bakersfield. We may have some questions, depends on what Mr. O'Brien asks.
Okay,
We may cover everything we would ask.
you'd like to go second. That sounds fine. Mr. Cooney, I see you're off mute as well. Do you have questions?
Yes, I do. I'm happy to go now. I don't have but a few questions. And so if you want me to proceed now, is that your preference?
I think what we'll do, yes, if unless anyone else speaks up, we'll start with you, Mr. Cooney, then I will turn to Mr. O'Brien and then Mr. Pierce. Is there anyone else who I have missed? All right, let's proceed that way. Mr. Cooney, I will turn to you.
Very good. Thank you. Good morning, Ms. Melton. How are you today?
Good morning, Mr. Cooney. I'm well. How are you?
I'm just fine. So I just have a couple of questions. When you were referring to the circumstances that the water master has been authorized from the Kern River interest to provide a notice to local agencies when there's been a flood control condition, is it correct that at that time, the Army Corps has already made its determination after the efforts of coordination that there's going to be a mandatory release occurring from Isabella, releasing Kern River waters from storage? So that's already happened in the case of a notice order. Is that right?
Yes, generally.
And also, when notice order is occurring in this coordinated practice and approach, that all of the requirements, I'll call them the intertie agreements. You referenced some of them, and I think North Kern has those exhibits as North Kern 56 through 61. There are actually, I think, 5 altogether. But my question, Ms. Melton, is that those agreements have various requirements and notice and procedures. Is that right?
That is correct.
And so that all of those requirements have been satisfied such that the intertie has been authorized to operate, and there is then a need to see if any local agencies can utilize that water in the basin. Is that right?
It's been a long time since I've looked at those agreements, but generally we're trying to absorb as much water within Kern County before it leaves the Kern County, before it leaves the Kern River system.
Right. And matter of fact, that notice that has typically been used actually recites that that is the goal, to hopefully keep as much Kern River water in the Kern County area to the fullest extent possible. Is that right?
Yes.
And so back to process, I was just simply asking that all of the requirements of the notice, excuse me, of the intertie agreements have been satisfied as they state when there has been an intertie discharge of Kern River floodwaters. Is that right?
Yes.
I think that's all the questions that I have. Thank you very much.
Thank you.
Thank you, Mr. Cuny. With that, I will turn to you, Mr. O'Brien. Do you, as I understand, you have questions for Ms. Melton, so please go ahead.
Thank you. Good morning, Ms. Melton.
Good morning.
I'm Kevin O'Brien, representing the Kern Water Bank Authority in this proceeding. And I didn't mean to imply by my earlier comment that my cross-examination would not be friendly. I like to think that we're all friendly here, but I just have a few questions for you. First of all, are you an expert in California water rights law?
I am not.
So your testimony should not be interpreted as providing any legal opinions regarding any of the law, the river documents. Is that correct?
That is correct.
And your testimony should not be interpreted as providing any legal opinions regarding the scope of any particular water right on the Kern River?
I'm not an attorney, so no.
In your oral testimony this morning, you described how the agency, if I may refer to Kern County Water Agency as the agency, uses the lower river right. Do you recall that?
Yes, I do.
And you described how in high flow years, the agency uses its storage rights in Isabella to achieve, I think, what you called maximum beneficial use. Is that correct?
Yes, the agency manages the lower river right to achieve as much benefit as possible,
Okay.
including the storage in Isabella.
Okay. And you testified that there have been times in the past where it has been necessary to divert water into the intertie, correct?
Yes, since the agency has had the lower river right in 2001, there's been one instance where the intertie is operated.
Okay.
2006.
But there were instances before 2001 where the intertie had operated, correct?
Correct.
Now you described a 3-part coordination process that occurs in high flow years. And I wanted to walk through those to make sure I understand them. You described the first stage as, I think you used the term pre-notice order stage. Is that correct?
Yes,
And you said that during that pre-notice order stage, the agency essentially tells other water users on the Kern River to divert as much Kern River water as they can, words to that effect. Is that what you said?
the agency does not do that. The Kern River Water Master does.
Okay. So at that point, the Kern River Water Master notifies other water users on the Kern River that essentially that they will be allowed to divert as much Kern River water as they're capable of diverting. Is that your understanding?
Well, I don't think it has to necessarily, I'm not sure what you mean by Kern River users. I'm not sure what you mean by that.
Well, when the water master sends out this pre-notice order notification, who does that go to?
It goes to water entities that can divert Kern River water.
Okay. At this pre-notice order stage, when the water master issues this notification we just discussed, is the water that's diverted by other water users on the Kern River considered surplus to the needs of the agency under its lower river right?
I'm sorry, can you restate that?
Sure.
Or repeat it?
I'll try to break it down. I know it was a long question. So we've talked about this pre-notice order stage where the water master issues a notification to other water users who have the capability of diverting water from the Kern River, correct?
Well, the first call is after all of the Kern River interests have delivered as much Kern River water as they can, or are taking delivery as much Kern River water as they can, then it goes into this pre-notice order process.
Understood. So now we're in the pre-notice order process, and this notification has gone out by the Kern River Water Master, correct?
Correct.
And then whichever entities that have the ability to divert Kern River water pursuant to the water master's notification would do so if they need it, correct?
Correct.
And my question is, at that point, when these other water users are diverting water pursuant to the water master's notification, from your perspective, are those diversions being made of water that's surplus to the needs of the agency under its lower river right?
Not necessarily.
So does the agency view those diversions as diversions of water under its lower river right?
So it's maybe perhaps a little more complex than that, in that it really depends on where the Kern River interests are at with their storage in Isabella, what water is accumulating under their right. So it may not be lower river water that's being offered out.
Let me ask you this, in this situation, in this pre-notice order stage, where other water users on the Kern River have diverted Kern River water pursuant to the water master's notification, do you know whether the agency has ever reported those diversions to the State Water Board under its statements of diversion of use as essentially water being used under the lower river right?
They have not. We have not.
Do you know whether any of the other or any of the second point parties, such as Buena Vista, have ever reported that use under their statements of water diversion use?
I do not know.
Okay. So we've covered the first stage of the three-part coordination process as you described it. And then the second stage is the issuance of the notice order itself, correct?
That's correct.
Now, can you explain to me how that determination that a notice order should be issued is made?
So generally, as Mr. Cuny said, it is during a mandatory release period. The Corps has saying you need to draw down the Isabella, you need to draw it down at a certain rate. And so as much water as possible is being diverted among the Kern River interests. And then you go to the process where you issue, the water master puts out a notice order calling for all Kern County water users that can take water off the Kern River to divert.
And is it correct to say that the notice order is only issued after a determination has been made by the Corps of Engineers that a mandatory release is going to occur?
I believe that is generally correct.
Now, in your direct testimony, you made a recommendation, as I understood it, as to how the State Water Board should proceed here. And as I understand it, your recommendation is that whenever a notice order has been issued by the water master, that would trigger there being water available for appropriation. Is that a fair summary?
Yes.
Wouldn't it make more sense, given the testimony you gave me a minute ago regarding the pre-notice order stage, to make that determination that water is available for appropriation at a somewhat earlier point in the process during these wet years, when essentially the water master has issued notification that there's excess water available for use on the Kern River?
No, I think you need to be sure that all of the Kern River interest needs are met before there would be any water made available, which is what happens in the notice order.
But when the water master issues the notification that we talked about in the pre-notice order stage, doesn't the water master, as part of that process, make a determination that all of the needs of, for example, the second point right holders have been met before that notification goes out?
But that's in the notice order, not in the pre-notice order.
So what's your understanding as to what triggers the pre-notice order notification by the water master? What's your understanding as to what the water master bases his or her decision on to issue that pre-notice order?
So as I think I mentioned a few minutes ago, that really the Kern River interests have varying amounts of water in storage. I mean, the situation can vary greatly. And then they are still accruing water on a daily basis. And so the pre-notice order is perhaps someone is managing their Kern River water. Now there's an opportunity for them to take additional Kern River water, perhaps. So the notice order is more about managing that water, the pre-notice order is more about managing that water supply among the Kern River interests. Then once that has been satisfied, then you would go into the notice order process.
So I take it from your testimony that the agency has no objection to a determination by the water board that there is water available for appropriation on the Kern River. Is that a fair statement?
Well, I think it's fairly complex. We've talked about the Kern River being flashy. I think if there's water appropriate, it's under these very narrow time periods, which is the notice order process.
You would be okay with that?
The Kern River has a process. The law of the river, it allocates water supplies to the Kern River interests. The Kern River interests have storage in Isabella. These water supplies are being managed. There's these extreme events. Maybe not all of them are extreme, but generally what we have seen is they've been more of an extreme type of event, and it's very diverse. So the Kern River is fully appropriated. So maybe I do not agree.
I'm sorry, but I'm a little confused now because I thought you stated in your direct testimony that the agency was okay with the idea of additional appropriations so long as the triggering mechanism was the notice order issuance. Do I have that right?
What the agency is recommending is that the AHO confirm the notice order process, that it reflects the historic and cooperative practice of the Kern River interests working with the Water Master and the Army Corps to determine when a notice order is active.
But that could lead in certain circumstances to the issuance of a new water right covering any surplus water over and above let me rephrase this one. I'm just trying to get at the question of whether the agency would have any objection to the issuance of a new water right permit so long as the notice order process, as you've described it, is respected and abided by.
Agency would prefer that the AHO confirm the notice order process.
I'm going to try it one more time. I understand that the agency would like to have the water board or the AHO confirm the notice order process, but so long as that notice order process is confirmed, does the Kern County Water Agency object to the issuance of a new water right permit for surplus Kern River water that's available following the implementation of the notice order process?
Objection asked and answered.
Overruled.
I will repeat, we would like confirmation of the notice order process.
I have no further questions.
Thank you, Mr. O'Brien. Mr. Pierce, do you have
Yes,
questions for Ms. Melton?
I do have a few questions, Ms. Kunze. Thank you.
Thank you.
And actually, I don't know if Ms. Mullen is available. I would like to focus on part of Ms. Melton's testimony, if possible.
I think we can do that. Ms. Mullins is usually quite available. So let's see, I believe the testimony is KCWA 23.
That's right. Yes. And
That's-
specifically, I'm looking at I'd like to have pulled up a paragraph 32 on page 8 of the testimony.
Mm.
A little further down to paragraph 32 there. Yep, perfect. That's great. Thank you, Ms. Mullen. All right, I'm ready. And Ms. Melton, just for the record, I'm Colin Pierce. We've met several times before, although it has been a few years, which I guess I'll credit to the pandemic. Good to see you again.
Good morning.
I just have a couple of questions. First, this is I'm looking at a copy of your testimony. In paragraph 32, you state that against the backdrop of the law of the river, D1196, the joint WAA, and the historic operation of the intertie, KCWA submits that there is only water available to appropriate when there has been a declaration of notice order, and including through the time period when the intertie operates. That's your testimony, correct?
Yes,
So it's your testimony that there is water available to appropriate when there has been a declaration of notice order, correct?
correct.
And in your testimony, you're not giving an opinion or giving any testimony on whether water forfeited by the Kern Delta Water District would also be considered unappropriated water, correct?
That is correct.
And your testimony only deals with the phase 1B issues, correct?
I'm going to object. I thought we were not in phase 1A and this is 1B, and we wouldn't be asking questions about 1A. This is impermissible cross on a subject that is not in the scope of this hearing.
Who's speaking? Okay, thank you.
That was Mr. Cooney, and I realize I'm doing the same thing. I'm flipping through my gallery, but I recognize his voice.
I'm sorry.
Okay.
I apologize.
You think you could say that objection one more time, Mr. Kern?
Yes.
Because I can't.
My objection to the question is that it is beyond the scope of phase 1B, that this is an issue concerning phase 1A, which is a matter submitted in December of last year and is not within the scope of this proceeding today. It's irrelevant.
Thank you, Mr. Cooney. I am going to overrule the objection because I think the line of questioning is appropriate to clarify Ms. Melton's testimony today and the scope of that testimony today, which is with respect to phase 1B. So Mr. Pierce, I believe you have if I remember right, I believe you have an outstanding question, but if you would please repeat the question.
I'll try.
Yes.
Ms. Melton, I just want to confirm that in giving your testimony, and specifically the testimony you're providing in paragraph 32 as to the existence of unappropriated water, you're not giving any opinions today on any of the issues that arose in phase 1A involving forfeiture release water. Is that correct?
That is correct.
Okay. Thank you. That's all the questions I have, Ms. Melton.
Thank you, Mr. Pierce.
Thank you.
At
Hearing
this,
Officer Kunze, I had just one question, and I know this is, it was raised in response to an earlier question from Mr. O'Brien. If I can have just one question, that's all clarification. And it's up to you. If not,
no, I understand, and I'm going to allow you to ask the question, and Mr. O'Brien, we'll see if there's redirect or if there needs to be a response. But Mr. Cooney, go ahead, please ask your question.
Yeah, thank you. Ms. Melton, and I think you said this, but just for clarity, your experience with regard to this process, notice order, and the water master and the authorization of discharges into the intertie under the agreements is in regard to the 2006 circumstance that was precipitated by Isabella Dam safety matters. Is that correct?
That is correct.
No further questions.
Thank you, Mr. Cuny. I think at this point, what I would like to do is I have one, I don't know if it's one question or one subject matter to ask questions about. So I'm going to step in and give this a try. To the extent you have knowledge on this. Ms. Melton, I noticed in your testimony in paragraph 20, I don't think we need to pull it up. I'll just read it. In paragraph 20 of your testimony, you state that one component of the lower river right is a contractual right to lease to Larry Lake Basin Water Storage District's entitlement in any year. KCWA currently and consistently exercises this right. And my understanding, correct me if I'm wrong, is that Tulare Lake Basin Water Storage District has an interest in a portion of the lower river right. Is that right?
That is correct. We have been, we have an agreement with them, and we pay them on an annual basis rather than providing water supply.
And in your experience, is there ever a situation in which both KCWA and Tulare Lake Basin have diverted Kern River water in the same year?
Since the Kern County Water Agency has had the lower river rights, there's been no diversion to Tulare Lake.
And do you know if Tulare Lake Basin's entitlement is based on one of its, you may not know, but based on one of its water right licenses issued by the State Water Board, or is based on another type of claim of right?
I cannot answer that question.
Thank you, and that's fair enough. And Mr. Keel, maybe you were listening. If you are listening, or maybe someone can give, there you are listening. At some point, I am going to have some questions from you just about your client's position. I don't think we need to do this now, but I am curious about your Tulare Lake Basin's position in this proceeding. I think it might be helpful for me to know. So that's just to give you a heads up, and I'll come back to you at some other time. Okay.
And Ms. Kinsey,
yes.
on that note, I think it would be helpful, just so our record is complete, to have this agreement that Ms. Melton just described between Tulare Lake Basin Water Storage District and the Kern County Water Agency in our record. Maybe the most efficient way to do that would be through Mr. Keel. It just seems like since this issue has come up, we ought to have the terms of that understanding clear in the record.
Let me just clarify first, Mr. Jacobs, is that agreement not, to your knowledge, that agreement has not been submitted as an exhibit to this proceeding?
I don't think we submitted it. We had to use some discretion in how many agreements to submit, but we can certainly submit it.
Well, let's do that. I think that makes sense. If you would please, at some point during the break, identify it, mark it, and we can get it in that way.
Thank you.
Thank you. And then I believe my next question will be for you, Mr. Jacobs, whether you have any redirect questions for Ms. Melton.
I do not.
And then I believe with that, I will thank you, Ms. Melton. Thank you so much for joining us today and taking the time to
Thank you.
testify in this proceeding. I appreciate it very much.
Thank you.
Can I just interrupt for one moment? This is the court reporter, Ms. Melton. Oh, where did she go?
She's here.
Yes.
I think you were reading in your direct examination by Mr. Jacobs. I believe you were reading from some paperwork, and there was a moment when you reiterated like about 13 different counties and names, and I'm not really familiar with. Is there any way for you to email me that one section of your piece of paper where you recited all the names of all the different?
I'm sorry, I'm having it. We can get you those names. Is that what you're asking for?
Yes, absolutely what I'm asking for. Yeah, I don't know the spellings, and there was something like Dudley, and I don't remember all of them, but there was like you know, a quick reiteration of like 20 of them. If you could just email me that. If you look on my screen, there's my email address. Just that one excerpt would be great from your paper.
We can
can
do
do-
that.
Yeah,
Thank you. I
it's
appreciate
in her
it.
testimony.
Thank you. I appreciate it. Thanks so much.
Thank you. And thanks to all of you for helping the court reporter. I think at this point, let's, what I propose is that we take a brief break, and then Mr. Jacobs, when we return, we can hear from your next witness. I understand, Mr. Young.
Sounds good.
All right, let's go ahead and take 15 minutes. We'll return at 10:25. All right, it's 10:25. As soon as I see Mr. Jacobs, I think we can get started. All right, I see Mr. Jacobs. I see Mr. Young. Mr. Jacobs, at this time, are you prepared to call your next witness?
I am. Let me quickly just close my door here.
Sure, of course. Good morning, Mr. Young.
Good morning.
At this point, will you please raise your right hand? Mr. Young, do you swear or affirm under the penalty of perjury that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may proceed, Mr. Jacobs.
Thank you. Good morning, Mr. Young. Please state and spell your name for the record.
Greg Young, Gregyoung.
And is KCWA 24 a true and correct copy of your testimony?
Yes.
And is KCWA 14 your curriculum vitae?
Yes.
Great. Please describe for us your educational background and summarize your relevant work experience.
Yes. So I am a registered California civil engineer. I have co-founded in January of this year Zanhero Inc., which is a specialized water resources consulting firm. Previously, I co-founded Tully and Young Inc., which was also a specialized resources firm in existence since August of 2004 and now has been replaced by Zanhero. I have a bachelor's of science degree in agricultural engineering from Cal Poly, and I have over 31 years of extensive experience in water resources throughout the state and in the Western US.
And what are the topics of your testimony today?
I'll focus in three areas: the joint water availability analysis, and talking about its conclusions, explaining the lower river right, and describing my thoughts on what would be the appropriate approach to addressing the question at hand in phase 1B.
Let me just back up. We had a microphone or something making noise there. You're going to explain the lower river right. Are you also going to demonstrate the accounting that tracks the diversions and use of that entitlement?
Yes, absolutely.
Let's start then with the joint water availability analysis. When you refer to the joint water availability analysis, to what are you referring?
I am referring to the water availability analysis that was submitted in response to the state board's letter requested from October 2018. And it is the joint water availability analysis that was produced and submitted in 2019 by several parties, including North Kern Water Storage District, City of Shafter, Buena Vista, and Kern County Water Agency.
And that letter is CWA 15, correct?
Correct.
Can you describe the methodology that was recommended in that letter?
Correct. Yes, the recommended methodology from the state board's letter was to do a comparison of the maximum historical use for the right for each month in acre feet and compare that with the maximum amount of water available per month by the wettest individual month and the wettest water year based on the historical stream flow records.
And did the water availability analysis letter have any further recommendations regarding how to apportion the water?
Yes, it did recommend that the water available in each month should be apportioned in accordance with the law of the river, under the assumptions that each water right holder will fully exercise their respective water rights.
And how did the applicants respond to the State Water Board's letter?
That was the joint water availability analysis that was submitted in August of 2019, again by North Kern Water Storage District, City of Shafter, Buena Vista Water Storage District, and Kern County Water Agency.
And did you participate in preparation of the joint water availability analysis?
Yes, I did participate along with the other applicants and their consultants. We had a long process. It was led by MBK engineers, and they worked on leading the development of the response. I participated in the process on behalf of Kern County Water Agency. I attended many in-person meetings at MBK, participated in phone calls, reviews of several drafts of what ultimately became the joint water availability analysis.
And do you recognize Kern County Water Agency Exhibit 16 as being that joint water availability analysis?
Yes.
And did you review Kern County Water Agency Exhibits 17, 18, 19, and 20, the underlying data sets?
Yes.
Can you briefly summarize the methodology and analysis contained in the joint water availability analysis?
Yeah, we followed the methodology that was requested by the board in the October 2018 letter and used the Kern River records, the daily records that are maintained by the city of Bakersfield. The joint water availability analysis identified the highest flow months and years and highest use months and years, and did the comparison as requested by the letter from the state board.
Okay. And what was the ultimate conclusion reached from this analysis?
That analysis concluded that there were only 12 instances when monthly Kern River natural flows would exceed the maximum monthly historic water use at First Point, Second Point, and Lower River.
Okay, so 12 instances out of how many months? What was the record used?
There was over 1,500, believe it was 1,503 monthly flow records that were used from 1893 through December 2018.
Now, does the joint water availability analysis perfectly predict whether and how much water will be available in the Kern River system?
It does not perfectly predict. It does a good job recognizing when it might be available.
Did Kern County Water Agency prepare an appendix to the joint water availability analysis?
Yes, the Kern County Water Agency did prepare an appendix for the joint water availability analysis, and I believe that's identified as KCWA 21.
Okay. And did you participate in the preparation of that appendix?
Yes, I did. I supported that with a memorandum that's within that appendix that looked at the Lower River Right reports and tracking that information, how that information can be characterized from the annual hydrographic reports and translated and represented from Kern County Water Agency's documentation of deliveries to its users.
Okay. And I'm going to refer to your piece of that as the Lower River Right report, okay?
Yes.
Now, where did the data underlying the Lower River report come from?
It came from the Kern River, the annual Kern River reports that are available, and it's recognized under the heading Hacienda Water District, which is the water right that Kern County Water Agency did acquire back in 2001. And that information is still reported as Hacienda Water District in the water reports, even up to current conditions.
Okay. Now, in preparing the Lower River Right report, what was the period of record that you chose to focus on?
I used the period from 1969 through 2018.
And why did your analysis start in 1969?
Well, as I explained in that report, there are two reasons that 69 and 83 were by far the largest flow years on record and seemed the most relevant to determining water availability and use. And the Kern River reports with information on the Lower River were inconsistent prior to 1969.
And why did your analysis of the Kern River records end in 2018?
At the time of preparing that appendix, that was the last available report from the Kern River Water Master.
Did you review and consider any more recently available Kern River records in preparation for your testimony in phase 1B of this proceeding?
Yes, I did look at the 2019 report that was subsequently available.
And what did you find regarding entitlement and distribution of water under the lower river right during this period, 1969 through 2019?
The lower river right, otherwise known as, again, the Hacienda Water District entitlements between 69 and 18 from those reports are summarized in table D1 of the lower river report and show the water entitlement in 15 years during that period.
What about 2019?
Yes, there was an entitlement in 2019.
Where did you derive that from?
Looking at the Kern Water Master's annual report for 2019.
Did you also look at the Kern County Water Agency's water use report for that year?
Yes, I did.
Okay. And can you describe, since acquiring the lower river right in 2001, when has the Kern County Water Agency received entitlements under the lower river right?
The Water Agency has received entitlements in 2005, 2006, 2011, 2017, and then 2019, as shown in the most recent report. And all of that, just for the record, all of that water was subsequently diverted by the agency to its member units or accounted for as evaporation or river losses in the reporting of the water master.
Now I think you just misspoke, but you said that the agency just diverted water for its member units. Those member units can divert the water themselves, correct?
Correct.
And then you have some excerpts of the Kern River records that are attached to the Lower River report. What do those show?
Those show I believe I took a sample month from the 2017 Water Master report that shows the daily reporting for a month in that period of time to show how the water the entitlement then gets tracked on a daily basis and how water goes into storage and out of storage and how losses occur. And then how water is what they consider flow. Water is released as requested by the agency.
Okay. Ms. Mullen, could you please pull up KCWA 21 and scroll to PDF page 26? Great. And could you please scroll down here? We'd like to look at this table D3. All right. Now, Mr. Young, this is from your Lower River report, correct?
Correct.
And what information is presented in this table D3, and what is the significance of this information?
This information that's in table D3 is the monthly values from the 2017 annual report that is under the Hacienda entitlement. And the recognition, these are the columns and the headings that are recorded in those Water Master reports of the water supplies that are provided under the, I believe it's 1962 agreement from North Kern to Buena Vista that are entitlements given to Hacienda. And this is a tracking of those water supplies by month, including the reservoir loss, and then the flow, which is the requested release from the agency to be able to be delivered. And then it tracks the end of month storage as it goes through this entire year.
And I think you mentioned there was an allocation from North Kern Water Storage District in Buena Vista. Do you understand what that is?
Yeah, that's pursuant to agreements as part of the law of the river.
Okay. And 2017 was that very large water year, correct?
Correct.
Okay. All right, and moving on from this KCWA 21. Did you review the written testimony of Holly Melton submitted on behalf of the Kern County Water Agency?
Yes, I did.
And do you agree with Ms. Melton's suggested resolution of the parties' competing applications to appropriate Kern River water?
Yes, I do agree.
And can you explain that?
Yeah, I believe the workable resolution would focus on processing applications when the notice, order, and intertie operations are occurring. That approach again acknowledges the limited availability of water and the significant historic records, but is flexible in allowing potential future diversions under the notice, order, and intertie operations protocols. More specifically,
Go ahead.
more specifically, there's really no flow rate nor total acre foot quantity that can be shown when water is available for appropriation in each year. Instead, the availability of water under the high flow notice, order, and intertie operation conditions depend on particular circumstances of precipitation, storage conditions, real-time conveyance, and numerous other factors that we have discussed in these proceedings.
Right. And then anything else? I mean, how do you, that resolution, is that something that you feel would respect the existing law of the river?
Yes.
Would that be consistent with Water Right Order 2010-10?
I believe so.
I've got no further questions. Thank you.
Thank you, Mr. Jacobs. Thank you, Mr. Young. I think in keeping with our past order, I will turn to you, Mr. Cuny. Do you have questions for Mr. Young?
I have no questions. Thank you.
Thank you. Mr. Pierce, do you still prefer to ask questions, or do you have any questions? I can ask you that first.
I have no question. I have no questions, Ms. Kunze.
Okay. Then I will turn to you, Mr. O'Brien. Do you have questions for Mr. Young?
I do, thank you.
And I should ask, Mr. Becerra, do you have questions? I saw I skipped you. Do you have questions for Mr. Young?
I do not.
Okay, that's good to clarify. Thank you. Mr. O'Brien, I will turn to you. Please go ahead with your questions for Mr. Young.
Thank you, Ms. Kinsey. Good morning, Mr. Young. Good to see you again.
Good morning, Mr. O'Brien. Good to see you.
I'm going to start with an exhibit KWBA 420, and I'll ask Ms. Mullen to pull that up for us. If you could scroll down just a bit, Ms. Mullen, I need to see subparagraph K. I'm sorry. Yeah, there it is. Okay. Mr. Young, I'll represent to you that this is a copy of Section 1260 of the California Water Code, and I'll call your attention to subparagraph K of that provision. Is it your understanding that this provision of the Water Code is the provision that gives rise to the requirement of preparation of water availability analyses?
I would like you to go to the beginning of this Water Code section.
Sure.
Thank you. I believe that, yes, this section in all of its entirety sets forth the elements that would be included in a water availability analysis.
And turning back to subparagraph K, Ms. Mullen, sorry. When that provision discusses the need to demonstrate a reasonable likelihood that unappropriated water is available for the proposed appropriation, is that the standard that you apply when you prepare water availability analyses?
Reasonableness as a reasonable engineer, that is a professional determination on each case as to the complexities of the water rights that exist and the agreements that may exist on each watershed. So when preparing any analysis of water supplies, water availability, there are numerous factors to bring into consideration prior to determining what is reasonable.
I understand that. I'm just trying to focus on the language of subparagraph K and make sure we have an answer to my question, which is whether that's the standard, the reasonable likelihood standard that you apply when you prepare a WAA.
Yeah, that the sufficient information to demonstrate that water may be available for the proposed application is the rule that I would use.
And that the demonstrate is of a reasonable likelihood, correct?
I'm not sure what exactly you're trying to determine to be reasonable likelihood. That's really becomes a statistical question at some point.
I'm not trying to play any games here, Mr. Young. I'm just trying to get a nice, clear answer to my question of whether subparagraph K is the standard that you apply when you are preparing a water availability analysis.
Yes.
Thank you. So it's not necessary when you prepare a water availability analysis to determine that unappropriated water will be available with certainty. It's really more of a reasonable likelihood, correct?
Could you restate that question, please, or just ask it again?
Sure. It's not necessary when you're preparing a water availability analysis to demonstrate that unappropriated water is certain to be available, correct?
Correct, because the conditions of a right that would be authorized could recognize all of the other conditions that are in play that might result in it not being available in any time in the future.
You've prepared other water availability analyses in your career, correct?
I have participated in those with several other parties at multiple times.
Is it fair to say each one of those analyses is different?
Each one of those analyses takes the same basic approach to evaluating whether water supplies are available and looking at the existing rights, the flow conditions, the other attributes that are going to be potentially affecting water rights, including fishery needs or other recommendations. And so in a general course, they're all the same. The details can vary significantly.
Okay, fair enough. The Division of Water Rights has not established one single methodology for water availability analyses in the San Joaquin Valley. Isn't that true?
That is true.
You talked about the letter that you received from Mr. Moody of the Division of Water Rights, which I believe is KCWA 15. Was it your understanding that the methodology described in that letter was being required by the Division of Water Rights?
It was being requested that we follow that methodology and that we could have an additional methodology if so chosen. Not a substitute. It did say additional.
Are you aware that Mr. Moody in his deposition testified that he really had no opinion as to the appropriateness or validity of the two different methodologies that were used in this particular instance?
Objection assumes facts, not evidence.
I'll withdraw the question, Ms. Kinsey. Let's go ahead and pull up Ms. Mullen, if we could, KWBA 400. Starting at PDF page 52. If we could start at line 16, please. Let's see. I think we need the previous page, Ms. Mullen, sorry. So starting on line 21, and then I think it continues to the next page. I asked Mr. Moody the question. So my question goes to the later process, and the question is whether you have any opinions as to the appropriateness or validity of any of the water availability analyses that were submitted to the Division of Water Rights in response to Mr. McCarthy's. We could scroll down. Memo, and the answer is no. Were you aware of that testimony, Mr. Young?
I was not.
Okay. Does that come as a surprise to you?
I do not know the context of the conversation at that point. So I'm not sure what the surprise would be.
Okay, fair enough. Who was the principal author of the joint water availability analysis?
MBK engineers.
Was there a particular engineer at MBK that took the lead on that?
I believe Mark Van Camp was the principal in charge.
Okay. Now, I'd like to refer to your written testimony. Ms. Mullen, if you could pull up KCWA 24. It's page 2 of the document. I don't have a PDF reference. In paragraph 6. There it is. Thank you. You described a few minutes ago in your oral testimony the methodology that was identified in the letter from the Division of Water Rights. And this paragraph, as I understand it, is essentially your summary of that methodology. Is that correct?
Correct.
Have you ever, in the course of your career, used this same methodology that was recommended by the Division of Water Rights in any water availability analysis that you've prepared?
As I noted a few moments ago, the analysis of any water availability is always going to begin with a full understanding of the water rights and agreements and other conditions in any watershed. And in this particular case, with the law of the river in place and the numerous agreements of over time, this is a very unique situation that is being recommended and was the water availability analysis to undertake. And so I have not done a similar in other cases because the agreements have not presented themselves in those other circumstances in the same manner.
Well, leaving aside the agreements, and I take your point on, obviously it's a complicated system from the standpoint of the prior agreements, but I'm just focusing on the actual methodology where you compared the maximum amount of water available per month, and then compared that to assumptions regarding use under existing water rights, but used different years of use to compare with different months of flow. And I may not be articulating that very well, but have you ever used a methodology like that before, sir?
Not specifically like this.
Would you agree that the methodology that was followed in the joint WAA is conservative in relation to the prediction of water being available for appropriation?
I think that this water availability analysis is a useful tool for assessing whether water was available for the appropriations. But is it a perfect tool? No. Is there a perfect tool in this situation of this watershed? No, which is why I am of the opinion that the notice order process makes sense to incorporate into any representations that the AHO, Ms. Coonsey puts forward.
But it was a conservative methodology, was it not, in terms of predicting the quantity of water available for appropriation? Wouldn't you agree with that?
Not necessarily.
Is it fair to say that California's hydrologic conditions are changing?
Compared to what?
Compared to the past?
What past?
Let's say the last 100 years.
There are ongoing hydrologic cycles that we're experiencing, and whether there is a long-term change in that is represented in several studies under the climate change conditions. That yes, there may be various instances of change in our hydrology, but have those manifested in a way that you could say it has changed? Not necessarily.
I want to make sure I understand that, Mr. Young. So you, as a professional civil engineer in California, you do not agree with the proposition that our climate is changing in comparison to the climate over the past 100 years?
I
Objection
believe
misstates his testimony.
I think that's well, let me think about the way that question was phrased. You do not agree with the statement. Isn't that what you said, Mr. O'Brien? I think that's not a statement of his testimony. Or maybe you can try the question again.
I'll try the question again.
Okay.
You're aware of the numerous scientific studies in the scientific literature about climate change, are you not?
I'm aware of several studies and analyses.
Let's do it this way. Ms. Mullen, if you could pull up KWBA Exhibit 423. And I will represent to you, Mr. Young, that this is a document that I obtained from the website of the California Department of Water Resources. And this discusses climate change basics. And Ms. Mullen, if you could scroll down just a little bit. To the paragraph or the sentence that appears under the heading extreme events, rain, flood, and drought. That text states, quote, climate models indicate that we are likely to see larger and warmer storms resulting in increased rainfall and flooding. The storms, however, may not bring more water overall, leading to more frequent or severe droughts. End quote. Do you agree with that statement, Mr. Young?
I'm not sure if you're asking me whether my, that I have run models on climate, or if I'm just taking what they're saying there and agreeing with what they're saying.
Do you have any reason to believe that that statement by the California Department of Water Resources is inaccurate?
Well, when you look at the history of monthly flows on the Kern River system, like measured at first point from the late 1800s, there is not a substantial pattern that you could point to that the Kern River hydrology at flows at first point are significantly changing in any manner that you could predict going forward.
But you have no reason to believe that going forward, there will not be increased flooding on the Kern River. Is that your testimony?
Objection misstates testimony.
I think that's a fair objection. I'll add to it, Mr. O'Brien. I had trouble following the question with the double negative. So
Okay.
maybe, can we try again?
I'll try to fix that. I'm just trying to understand your position as a professional engineer, Mr. Young, on the subject of future climate change. And this statement that I read to you indicates that climate models indicate that we will see larger and warmer storms, which will result in increased rainfall and flooding. Do you see that?
I see that.
Do you have any reason to believe that in the future, the weather or the hydrology on the Kern River system will be the same as it's been over the past 100 years?
Objection, relevance. And I understand we're allowed to go outside the scope of direct, but now this is a hugely complicated scientific topic that is not directly relevant to what Mr. Young has testified about.
May I respond, Ms. Kinsey?
Sure.
Mr. Young has presented a water availability analysis, which by its nature is a predictive tool to predict what is going to happen in the future. Climate change is a recognized scientific fact. And if Mr. Young does not believe that climate change is real, then I think that goes very directly to his credibility as a witness. So I'm simply trying to understand his professional view on the subject of climate change as it relates to the Kern River.
Okay, but he hasn't said anything about not believing climate change is real, and his report in no way addresses climate change.
Well, I'm simply trying to understand what his position is. I don't think I've gotten a very clear answer to that.
Well, let me jump in here. So I'm going to overrule the objection, but with limitations on where we're going. I certainly don't want this to end up being a debate about or a test about whether or not a particular witness, quote, believes in climate change. I mean, I think that's something we don't need to address here. So as you did state, Mr. O'Brien, let's keep this focused on the Kern River. I do think it's appropriate to ask questions about Mr. Young's assessment of future supplies as it relates to the water availability analysis. So to the extent we're talking about potential changes in the pattern of precipitation, the amount of precipitation, et cetera, things like that, I think that's an appropriate line of questioning. So I will hand it back to you, Mr. O'Brien.
Thank you, Ms. Kinsey. Mr. Young, do you think increased flooding on the Kern River in the future is likely to occur?
It may occur. It also depends on what you mean by flooding. I guess that's a term of art, because water, if we're talking about flow at first point or flow at second point, when you're trying to define flooding, what exactly does define flooding? The operations of the reservoirs, the potential inflows below from tributaries below the Isabella Dam, all affect flow conditions, conditions of groundwater elevations, opportunities to restore water, the timing. There's flood curves that were shown in earlier testimony for Isabella. Those can be modified. So you're asking a very open-ended question about what is flooding. So can you please maybe re-ask in a more specific way?
Sure. So you're familiar with the past hydrology of the Kern River, and in particular, the years in which the intertie operated, are you not?
Yes, I am.
In your opinion, is it likely that in the future, events such as occurred in the past where the intertie operated will occur as a result of climate change?
I believe there will be occurrences in the future where the intertie, the opportunities to operate the intertie could occur. And that's why the notice order is in place, because the prediction of that is not, it cannot be based on any specific events of like a flow condition or a reservoir condition.
But I think the answer to my question is you think that's likely to occur, correct?
I think it is, there is always the potential for waters to be available to the intertie based on the conditions that are occurring in that future year, which is again why the notice order provides that flexibility to allow the diversion for beneficial use of that water at that point in time.
Let's turn back to your written testimony, Ms. Mullen, paragraph 13. And starting at line 8, you state, quote, "I agree with the proposition that a reasonable and workable resolution of this matter would focus on processing applications for appropriation of water when the, quote, notice order, quote, and intertie operations are occurring." Do you see that?
Yes.
When you use the term focus on processing applications for appropriation of water, what do you mean by that?
In the beginning of that line is a reasonable and workable resolution to this phase 1B question. And that would be that processing of applications for appropriation that are associated with flows to the intertie would be processed in that manner when there is a notice order. So in other words, if a notice order is triggered or is sent out, as Ms. Melton was testifying, at that point in time, appropriations would could potentially be in place.
So you don't have a problem with the idea of a new water right permit, so long as it is tied to the notice order and intertie operations as you described it, correct?
I believe that's a reasonable resolution.
So the answer to my question is you're okay with the idea of a water right permit being issued?
In association with the notice order? I'm asking that, sorry.
Yes, in association with the notice order.
And my reasonable opinion would be that it would make sense to have appropriations that would trigger after the notice order or in relation to the triggering of the notice order.
And those would be new appropriated permits, correct?
I believe that is the entire point here with multiple water applications pending.
Well, I'm just trying to get a clear answer to my question, sir. And my question is whether you would support the issuance of a new water right permit so long as that is tied to the notice order and intertie operations as identified in your testimony.
Yes.
Thank you. Now, did you have a chance to watch Ms. Melton's testimony this morning?
Yes.
And you heard her describe the, I think she called it the three-part coordination process that occurs on the Kern River during wet years.
Yes.
And she described three different stages. The first was a pre-notice order stage. The second was the notice order. And the third was the actual opening of the intertie. Is that description by Ms. Melton consistent with your understanding of how things work on the Kern River in wet years?
It is my understanding from the agreements I have reviewed as to the operations related to the intertie and the notice order. You added wet years in there, which is not necessarily the situation.
Fair clarification, Mr. Young. Could you describe your understanding of the pre-notice order process?
No, I have only read some materials about the agreements. I understand there is a procedure, and I am not familiar with all of the details of that procedure.
Okay. Ms. Melton testified that diversions that are made by other water users on the Kern River following a pre-notice order notification by the water master are not reported to the State Water Board by the agency under its lower river right. Is that consistent with your understanding?
I do not know.
Let's turn to 2017. Do you know how much water the Kern County Water Agency used under the lower river right in 2017? And when I say the agency, I mean either the agency or transferees of water by the agency.
Yes, and I believe that's pretty detailed in our the appendix. The portion of the appendix we added to the joint water availability analysis, and this particular table D4.
Can you just, by referencing table D4, can you just, why don't we pull that up if we could, Ms. Mullen? Thank you, Ms. Mullen. So this is a summary. Did you prepare this, Mr. Young?
Yes.
And this is a summary of what?
This is a summary of the agency's tracking of their entitlement as it relates to the information that was reported on the Water Master's report on table D3.
So is it accurate to say that this table D4 reflects all of the Kern River water used in 2017 under the agency's lower river right?
With the addition of water that was added to storage and carried into 2018. That is not on this table.
And that would have been water put in storage at Lake Isabella?
Correct.
Do you know whether the agency reported all of the water reflected in this table to the State Water Board under the state statements of water diversion and use?
I do not know.
You're not involved in that process.
No, I am not involved in their water reporting process.
Of the water shown in this table D4, do you happen to know the terms of the water sales or transfers that were made to these different water users?
I do not.
I could have just a minute, Ms. Kinsey. I think I'm maybe
Sure.
done, but I just want to check my notes.
No problem.
Yes, I have no further questions. Thank you, Mr. Young.
Thank you.
Thank you, Mr. O'Brien. Before I turn to you, Mr. Jacobs, does anyone else have questions for Mr. Young? Mr. Jacobs, do you have any redirect for Mr. Young?
I do not. Thank you.
Thank you. Then with that, Mr. Young, thank you so much for your testimony today. I appreciate you being here.
Thank you.
Thank you. I believe at this point, Mr. Jacobs, it would be an appropriate time to consider moving KCWA's exhibits into the evidentiary record.
Okay. I had an,
I'm sorry, unless you need a break or we need a moment to organize those.
no, the only thing I wanted to talk about is we discussed earlier whether or not the AHO wanted all of the applications into the record. These were part of phase 1A, I believe. We haven't submitted those with our testimony, but we could do so on rebuttal, or we could do so now or later. Up to you.
Why don't we just do that with, well, I think it'd be easy enough to do it with rebuttal. We can,
Sure.
everyone can, it's a chance for everyone to bring in additional evidence from the record. And I will note here that at least with respect to the applications, we can do that.
Okay. And then the other item is you asked about an agreement between
Yes.
the agency's predecessor to the Lower River Right and Tulare Lake. I believe there are actually two agreements. I'd like to discuss that with my general counsel and also with the Tulare Lake folks, just to make sure we're on the same page. And there are a lot of agreements, and I want to make sure we have the right ones and all of them.
Yes.
So I could, we can move the rest of our exhibits into the record now, and I could submit those on rebuttal, the two agreements I'm referring to.
I think that makes sense. Do you have any concerns with that, Mr. O'Brien?
I do not.
Okay, I don't either. I think that makes sense, and that will give you time to have those conversations, and we don't have to do it on a short timeline. So that makes sense. With that, I think I will look to you, Mr. Jacobs, to normally I read off the exhibits, but I didn't actually write them all down because we went through these witnesses more quickly than I anticipated. So I will turn to you if you are prepared to read off or summarize the list of the exhibits that you are offering into evidence at this time.
Sure. So in summary, it's KCWA 1 through 24. And you would like me to read off each one individually?
No, I just wanted the
Okay.
numbers. And then are there any additional exhibits from phase 1A that may have been submitted by other parties that you're seeking to move in?
No.
Okay. So at this time, would you like to offer into evidence KCWA 1 exhibits 1 through 24?
Yes, please.
And are there any objections to the acceptance of those exhibits into the evidentiary record?
No objections.
So at this time, KCWA 1 through 24 are accepted into the evidentiary record for phase 1B. And I believe with that, we have for now concluded the case in chief of KCWA. And keeping in mind, you may have rebuttal exhibits, which will, cross exhibits that we'll get to later from all the parties. I think it makes sense for us to break 10 minutes early and return at 1 o'clock and probably just cleanly start the case in chief for North Kern. Does that make sense to you, Mr. Kinney?
Yes, that's just fine. Thank you.
Okay. Are there any other procedural matters we should talk about before we break for our long lunch? All right, great, excellent. We're moving along. Thank you, and we will return at 1 o'clock and get started right away.
Ms. Kinsey, do we need to log out of the Zoom meeting?
We do. Thank you for reminding me. Yes, please do log out. You'll actually, if you don't log out, I've been informed you'll be kicked out. So either way, you will be required to log back in after lunch.
Thank you.
Thank you.